I'm Daun, a research fellow at the Center for International Law. CIA has been organizing a series of the webinars on maritime autonomous surface ships and the 1982 United Nations Convention on the Law of the Sea. I'm very delighted to welcome speakers and participants to the third webinar on MAS, Maritime Law Enforcement and Maritime Security. Just a little housekeeping before we get started. If you have any questions, please type your question into the Q&A box, which is at the bottom of your screen. We will bring them up during the discussion, or we will have time for the questions at the end. Without further ado, we will start the webinar with welcome remarks. It is my great pleasure to introduce Dr. Niloufar Orar, Director of the Center for International Law, for welcome remarks.
Thank you so much, Dawoon. And as Director of the Center for International Law, it is truly my great pleasure to welcome all of you, those of you joining us from Singapore and from all different parts of the world. I also extend my sincerest appreciation to our most distinguished panelists, Professors Natalie Klein, Anna Petrig, CIL's very own Pia Benoza, and of course, our moderator, our very own Professor Beckman. So today's topic is truly timely, it is important, and personally, I find it to be quite fascinating. We are in an era of rapid advancements in robotic technology and artificial intelligence, and this has all spilled over into the maritime domain. The technology is truly amazing and moving quickly. However, the existing international legal framework for shipping is based on centuries, even millennia, practice of human-manned ships. But with the onset of autonomous technology, this is changing. It is indeed a brave new world for the seas. So many questions, notably how existing rules of international law, such as the 1982 UNCLOS and IMO instruments, will adapt to these changes. So today, we have some of the top global experts on the law of the sea to illuminate us on these complex issues today. And I personally will be listening very attentively. So once again, I thank you all for joining us. Dawoon, it's yours.
Thank you, Niloufar, for the excellent opening remarks. Now, I would like to introduce Prof. Beckman, the head of the Ocean Law and Policy Program at the CIA. Prof, you have a floor.
Okay, we're looking at MAS from the perspective of maritime security, looking at it from the point of view of the maritime power that may want to use unmanned vessels, but also from the perspective of the coastal state that may be concerned about outside powers using unmanned vessels for either collecting intelligence on its natural resources or other nefarious purposes. So it is my great pleasure to have three experts with us today. First, Dr. Anna Petrig, the Chair of International and Public Law from the University of Basel in Switzerland. I think you believe that her short bio was put on the website, so most of you are aware of that. She's been involved in the IMO's regulatory scoping exercise on autonomous ships, and she was also served as an ad hoc judge before two cases before the International Tribunal for the Law of the Sea. And I know she's written on the issue of autonomous vessels and the use of vessels for committing maritime crimes. Our second panelist, an old friend, Dr. Natalie Klein, a professor of UNSW, the University of New South Wales in Sydney's Faculty of Law and Justice, head of postgraduate studies. She is heading as a research grant from the Australian government looking at autonomous vessels. She has written, I think, more than anyone else so far on this topic as far as our research indicates. She served as a litigator in an arbitration practice before. She's been a consultant in the Office of Legal Affairs at the UN. And I think she's well known among every international law of the sea expert in the world. So very welcome to have Natalie join us. Our third researcher is our very own, our third panelist is our very own Maria Pia Benosa, a research associate at the Center for International Law, part of our ocean law and policy team. Pia did her LLM in national security law at the Georgetown University Law Center with the Fulbright Foreign Student Program grant. She also previously held the Shirley Amarasinghe Fellowship at the UN Division of Ocean Affairs and Law of the Sea. She taught public international law at the University of Philippines College of Law. She has a great interest in use of force at sea, women in the maritime community, protection of maritime diversity. We're very happy that she's joined us at CIL, and we are confident she will add to the discussion in the workshop today. So without further ado, I think we will perhaps divide our discussion into 3 parts. First part would be looking at United Nations Convention of the Law of the Sea provisions and the commission of crimes by autonomous vessels. In other words, criminal elements using unmanned vessels to commit crimes. How does the coastal state, or how do other states outside of national jurisdiction, given the provisions in the Law of the Sea Convention, how do you cope with the issue of maritime crimes? Second issue, we'll look at rights and obligations of states on passage rights under the Law of the Sea Convention. All vessels, including submarines, have a right of innocent passage through the territorial sea. They also have rights of transit passage and archipelagic sea lanes passage, freedoms of navigation. But how do you balance these against the rights of the coastal state to protect the areas under their maritime zones, under their sovereignty, and so on? And then the third issue we'll look at is the whole question of warships and other government ships on non-commercial service that may have immunity from the jurisdiction of another state. How do you deal with that issue when it comes to vessels that don't have crew members? As we'll get into the issues of ship, the issues of submarines and other underwater vehicles having to surface and fly their flag when they exercise innocent passage, and so on. So without further ado, let's begin by asking one of our researchers. Perhaps Anna, you could start with some of the issues. Have you seen them in terms of the use of autonomous vessels to commit crimes? What are the legal issues that we should be concerned about?
Thank you very much for giving me the floor, and also for the kind invitation to join this panel. It's a great pleasure and honor. Nilofer already said in her introduction, if there is one truism throughout the 1,000 years of maritime history, it's that ships have persons on board, and this assumption is underlying all rules, and mass really query this basic premise. And this also holds true for maritime security rules. They are based on the assumption that the perpetrators are on board the offender craft, and for enforcer mass, you have the novelty that there is no law enforcement official embarked on ships authorized to enforce the law. And as a consequence of this, you cannot longer take it for granted that enforcers and suspects encounter each other at sea, and that there is a physical human-human interaction in theater where you could also exchange documents, where you could do interrogations, etc. So there's still human involvement if offenders or enforcers use mass, but the manner and time and location of human involvement is very different. And that brings up a lot of legal and practical challenges. So the question is, how do you communicate with these autonomous enforcer ships? How do you address requests to them? How do you carry out stopping, boarding, etc.? And to answer these questions, we have to be aware that there are very different forms of offender mass. You may have big cargo mass in the future, where you could have offenses such as drug smuggling or smuggling of items which are under an embargo, or you could have stowaways. But then these ships will most probably be regulated by IMO rules, and they have certain equipment on board to communicate, etc. They will most certainly fly a flag. But then you have also different types of offender ships. If I think of the attacks carried out by the Houthi rebels in the Red Sea, you rather have retrofitted pleasure boats equipped with GPS technology and remotely controlled, or you have small crafts used for drug smuggling, and with these ships you have different types of challenges. So of course you have to adapt many things. If I take, for instance, the order to stop, the problem is you cannot use traditional means. You have no one on board who is the interlocutor. So the question is whether you can use different means, and UNCLOS is rather based on the assumption that you would be very close to the ship, but it doesn't foresee for distance signaling. But there's also case law saying that all these provisions have to interpret it in light of modern use of technologies. I don't know whether I should already go into many details as regards like boarding or right of visit, or whether maybe others would take the floor first.
I think it was really helpful for Anna to point out the different types of maritime autonomous vehicles that we could be dealing with that are being used in crime. And I'd take that one little step further, as Anna also knows, with the levels of autonomy that are involved too. So just before we get to the right of visit and right of hot pursuit, I think it's really important to bear in mind that that level of autonomy is going to vary across those types of vessels or vehicles as well, depending on whether they're remote controlled, whether they are fully autonomous and so they are programmed to respond in different ways, or if you actually have a human operator who is sort of there, who can potentially be receiving messages in real time, even if they are not physically on the ship. And I think that level of control that someone might have, even if not on the ship, but perhaps still in real time, is going to affect the ways that we can respond to these rules. Because, you know, the assumption will be that if there is somebody controlling it somewhere, then that might make your communications a little bit easier. But of course, if you're dealing with a criminal enterprise and you're giving a signal to stop, even if the operator is in another country and they get that, they're not necessarily going to stop, are they? So I think what we have to anticipate with the right of visit is that, you know, if you have a regular enforcement vessel where there are humans involved and they're encountering a mass, there's still going to be a question about, is it of a size and scale and functionality that it is flagged to a state, in which case we would still expect that there would be contact with the flag state officials for consent to board. I was just saying, if you have a large cargo mass that has potentially drugs on board, it's going to be more like a traditional dynamic, as Anna was indicating. But I think that does change when you start thinking about some of the semi-submersible type US, and whether we get to the point that they are also operated autonomously. They're not going to be flagged, of course, or registered to a particular state. And in that situation, how you go about the enforcement, the level of force that might be used, I think the rules of the game might change a fair bit in that sort of more about those enforcement powers, but let me leave it at that to start with.
Okay, good. Anybody else? Anna, do you want to reply, or Pia, do you have anything?
Maybe to go a bit into more technicalities as regards the right of visit, like one of the questions is, can offender mass, if the ship is without a crew on board, commit the offenses listed in Article 110 UNCLOS. We have this piracy, slave trade, and unauthorized broadcasting, and I guess only piracy is of relevance today, but already the question, can a ship which is not manned commit piracy? Because in the definition you have this reference that the illegal act against the other ship is committed by the crew of a private ship against another ship. So can that be a remote crew? Yeah, maybe yes, but what if it's an autonomous ship, a level 4 ship? There is no immediate control by someone over that ship. These kind of questions will certainly have to be solved, and there are different views on how to approach interpretation. Some argue that you can interpret these provisions very broadly in an evolutive way, because UNCLOS would be a framework convention. I was a criminal lawyer in the past, so I tend to argue for a stricter view to give enough room for the principle of legality and rule of law. So depending on how broadly you interpret these offenses, unmanned in offender mass can be covered or not. And then there are interesting questions also as regards the right of visit, whether you could do a remote or a virtual visit, because traditionally, and also the wording of the provision concerning the right of visit, it's the idea that the boarding team goes on board, that there is someone you talk to, then you inspect ship papers, you determine nationality, then you inspect cargo. So a lot of physical acts on board, human-human interaction. So can you also carry that out virtually without boarding the ship? You could use cameras to identify the IMO number or the ship markings and then contact the flag state, or maybe these cargo mass will also have e-certificates, or most probably they will have like digitized ship papers. So you could inspect all of that without going on board the ship, and you could even do a partial search with using a new technology like aerial drones, which gives you a view of the ship from the outside. There are also subsurface enforcer systems where you can identify, I don't know, moon pools or trapdoors or drag prohibited items. There's even like sniffers which can detect certain cargo without going on board. So all these questions need to be answered in light of this Article 110, which the wording is very much about a boarding team going on board the ship. And some say that such virtual visit would be much less intrusive, so it should be permissible, because in any event, if you can do more, you can do less, but I'm not so sure whether it's less intrusive than a physical search, because if you access information system, for instance, you cannot do that in a very surgical way sometimes, so you may get more information than that just about nationality or cargo. And one of my big questions is also or the danger that this is done in a clandestine way, because the traditional exercise of the right of visit cannot go unnoticed to the master and the crew. But if you do it remotely, it could be kind of done without really being known by the master or the ship. And we have different safeguards in the law of the sea, for instance, in the SUA protocol, which stipulates that the boarding state must ensure that the master is advised of the intention to board. And so these kind of safeguards, I think they very much require that the right of visit cannot be exercised in a clandestine manner, but there's just more room also for abuse, I guess, if you do not go on board. And also all the means described in the law, how you identify yourself as a law enforcement official, it's still, the wording is about ID cards, etc. So that's no longer going to work. So what is the functional equivalent? How can we prevent abuse? How can we know whether it's a jerk or a law enforcement official doing a virtual search of your cargo, etc.? These are the types of questions which need to be answered, and I guess answered rather soon, because the first technology is already out there.
Yeah, I think you've raised one very interesting issue, and that would be, it also relates to the rights of the coastal state to enforce its laws on smuggling or other criminal laws, or to prevent passage which is not innocent. Now, I think that it follows from our previous workshops as well, is there has to be some way that the coastal state authorities can communicate with a mass vessel. And you raised the issue, well, it will have an IMO number and it should be flying a flag. So if the coastal state authorities are able to electronically check with the flag state through the IMO number to verify the flag, and these days you could send a picture of it as well, then the coastal state could inform the flag state as to what information it has, that they have information this vessel may be involved in smuggling drugs or smuggling people, and request permission to board, etc. Then it could work quite smoothly. But that all assumes that there is a means of communicating with person in charge. There's no master on charge, but then somehow there has to be at a remote control center or in the flag state, someone you could communicate with on behalf of the coastal state who that can represent that vessel's interests. I think, I don't know, Natalie or Bia, have you thought that one through? Or Anna, if you wanted to reply. I think that's, I don't see any objections of the coastal authorities or any naval or coast guard vessel being able to identify and check on, verify the flag with the, electronically with the authorities of the flag state.
No, I think that's right. You can take those initial steps if you know that. I think that's correct. If you've got sufficient information to be able to get in touch with flag state authorities, you should be able to get the information that you need. But of course, implicit in what you're saying is that there is not always clearly going to be a flag state. And again, that question about the level of autonomy of the vessel. But I mean, there's some interesting considerations about the steps that could be taken for law enforcement, but maybe Pia's got some ideas on that too. I jumped in.
No problem, Prof. Well, nothing specific, but I think, well, we said that we were not going to discuss the RSC, but I think some of the opinions that were exchanged during the regulatory scoping exercise were specifically this matter of communication, but also at a very basic level, how to identify masts as being masts visually, where they are interacting in an ocean space where you have conventional vessels all in the same operational arena. So for me, that's also one of the starting points that we have to consider apart from communication. I don't have the technical answers for the communication problem, but certain ideas about light signals and specific design parameters would be the obvious stream to follow to be able to answer these questions.
Because aren't we also back to, if the vessel is flying no flag, then it has no protection. If it's then the coastal authorities can simply board the vessel. You might want to try to find whatever IMO number to verify if there's not flag. But if they're basically a stateless vessel, if you cannot identify a flag or clarify, and therefore any state's naval authorities Coast Guard could board it. Now, you're not going to do that without some information, perhaps, that they're engaged in illegal activity. But so the question always is, what if they're flying a flag and then you are not able to contact? Some flags are available 24/7, would able to respond within minutes to verify whether the vessel that you've contacted them about, the particular IMO number, whether it's under their registry or not. Other vessels, you might get a busy signal or no answer from an email. So then the question, what do you do in those circumstances? You have a vessel that you have perhaps are suspected of smuggling drugs, but you can't verify whether the flag they're flying, and there's nobody on board to communicate with. Now, if they're controlled remotely or by a remote control center, then how do you find out how they're being controlled? And if you can't find out, what are your rights? I think those were the gaps that are in the law.
It also gives rise, Prof, to questions on the amount of force that you can use against these unmanned vessels. You know, we have all these case law about what kind of signals and your degree of reasonableness and humanity that you should apply, which is out the door now when we discuss criminal mass. So how are the players going to adjust to that? So that's my.
Maybe if I can follow up on what Pia said on the use of force, that's a very interesting issue, because it's true that use of force standards like necessity, reasonableness, and proportionality, that has all been developed with the idea that you have a human-human interaction. So you protect the right to life of the enforcement official and the right of life of the suspect. And if you don't have a human being on either side, that just changes the parameters and also the reactions and the readiness also to use force. The problem is if you have, let's say, a semi-submersible craft that is suspected of smuggling drugs, and it doesn't respond to your, if you query it, it doesn't respond. You don't know whether it's simply non-compliant or whether it's unmanned and does not have the ability to respond if you use force. And this is crucial because often it's argued that you can use force, that the threshold to apply force is lower, and that you can give a more robust response if the unmanned craft is, or the craft is unmanned, but how to make sure that there is no one on board. If you have these drug smuggling boats, it's pretty difficult to say whether they are manned or not if they don't respond. And then the question is also if you, what about use of force, which is not physical force, because all the standards have been developed for the kinetic force use of force, like warning shots, disabling engines by firing a motor, etc. And so that's the idea that there is someone to impress on board who changes the behavior if you use force, but that's not going to work. So the question is also if you can disrupt navigation and communication frequencies. And I'm a bit reluctant because it sounds very easy. You may bring a ship to a halt, but it can also go out of control because we know from cyber crimes or cyber attacks that hackback, so active cyber defense or actions against an identified source of malicious use of cyber operations, and responses to stop the malicious activity has been very difficult, to have them very tailored and targeted. And so I'm just wondering how safe such a disruption of navigation and communication frequencies would be. And again, there are standards which stipulate in the SUA Convention, also in the UN Convention against illicit traffic in narcotic drugs, which say that every enforcement measure must be taken in a way that the safety at sea is not endangered. So if you do law enforcement in a way which is, you know, maybe having unintended consequences, you may also endanger other ships. So the safer option is maybe to destroy hardware, that the unmanned ship cannot communicate any longer. But these are just novel issues, like the whole use of force will change too.
Okay, let me come back. I think one point we have to not lose sight of here, from our, especially for our listeners, the rights of the state that wants to enforce the rules depends in large part on where is the vessel that you suspect. If it is within your internal waters, it's your territory. You have very wide discretion to enforce your laws. If it's within your territorial sea or archipelagic waters, which are subject to your sovereignty, foreign vessels have a right of innocent passage. But unmanned underwater vehicles or submarines must surface and fly the flag. So you might be able to do depth charges or whatever to encourage them to surface if they don't. But you would also have, there's a clear set of rules. If they engage in any particular activities, then they don't no longer have the right of innocent passage, and you'd be able to enforce your rights. But again, you would want to be able to communicate with that vessel. There's no master on board, so you'd want to try to be able to communicate with whoever is in charge if it is remotely controlled. To say, we have evidence your vessel's engaged in smuggling drugs. We would like you to, we'd like to board an inspector, we'd like your permission, etc. If there's a way to communicate, now if there's not, or criminal elements and they're not going to respond to you anyway, then you've got to, then the coastal authority has some hard decisions to make as to what level of force you might employ. I mean, that's the way I look at it. But I think I keep coming back to the whatever the IMO comes up with, they've got to set up a system where the coastal or port authorities are able to communicate with that vessel and or communicate with whoever is controlling that vessel. Now, maybe it's the flag state gives you the handphone number of the remote control operator sitting in India, whatever, but at least you've got to be able to communicate with whoever's in charge. And therefore, they would be able to give you permission to board or order the vessel to stop or so on. If you're not able to do that, if it's in your territory, then you probably have much greater rights than you would have outside your territorial waters.
But I think it's still going to be a question of scale as well, and the gradation that is normally followed for law enforcement in any event. So if you can't communicate, if someone's not responding, do you just shadow that suspect vessel for a while in the hope that, you know, someone wakes up and gets your message and comes back to you? So there is that option that, of course, you know, if the vessel is leaving your territorial sea, then a different set of considerations come in. But I would expect, you know, those rules around reasonableness and proportionality are going to have to be adjusted for these vessels, but we would still expect that kind of gradation as suggested. I hadn't thought so much about Anna's point about there could be someone on board and you can't necessarily tell, because I think otherwise your rules of engagement would be that some of the considerations would allow a level of force that might not otherwise be applicable.
Yeah, so that comes back to that key point, is if through the IMO number and flag, if you're able to find out whether there is somebody on board or whether there is a remote control operator, then at least you're able to communicate with the vessel. When you're not able to do that, it creates very difficult problems from the perspective of the coastal state that's trying to protect its legitimate interests against an unlawful activity. It's a tricky compromise, and I agree that somebody's got to think this through and come up with some, at least, best practices.
And I think it's going to be a different question as to whether you're dealing with sort of commercial vessels that are going to be the cargo ships operating, as compared to what might be a smaller craft involved in smuggling operations. And then, of course, state-owned craft as well, that are also autonomous, because then, once again, the rules and expectations are going to be a bit different. So a lot's going to depend on size and functionality each time, I think, for the vessel concerned.
Yeah, and that's going to get, go ahead, Anna.
Yeah, if I may follow up on that, and as regards like cargo mass, which would fall under the IMO rules, I guess the assumption now, or the basic idea during the IMO's regulatory scoping exercise, was really that they that the same level of safety must apply, and there are already guidance out there for trials of mass, and there it's clearly said that the same level of safety and environmental soundness, security must be ensured. Of course, then how you implement these standards, that will be differently than for traditional ships. And that's also why IMO speaks of a goal-based instrument where you set out what results must be achieved, but that there would be different means on implement these standards. And I guess also from Article 94.4, it's kind of clear that the flag state must ensure safety at sea and take respective measures, and these measures must also pertain to the use of signals, maintenance of communications, and prevention of collisions. So the theoretical framework is there, but then I fear that we will have also what today are flag of convenience, flag states which are not very eager to enforce standards. And there is now also discussion whether if you, with remote controlled or autonomous ships, you have the bridge, you take the bridge ashore. So one of the bigger question is, are you obliged to have that bridge ashore in the flag state? Or could it be a third state? And in UNCLOS, there is no such thing as an operational state, but still, it's not so clear. And for effective flag state enforcement, that's really key. If I think Switzerland has also a flag and some ships, and if I imagine the scenario that the remote operator of a Swiss flagged autonomous ship would not be in Switzerland, most of the Swiss laws would not extend to an operator sitting in another territory. Just very exceptionally, some criminal offenses like core crimes, international core crimes, their Swiss criminal law or Swiss law in general would apply extraterritorially, but otherwise not. And then the whole thing of enforcement. So the flag state would essentially be stripped of means to enforce the law. So I guess it's key to enforce all these rules about communication and standards, that the bridge is taken ashore to the flag state, and that you don't have third states which just host these centers as a business case rather than with the true interest of having a certain level of standards.
Okay, good. Somebody else want to come in, or maybe we should go to some of the questions. I think we're coming back to that issue of remote control operators and the flag state responsibilities. It's been a theme in our first two webinars on this subject as well. And that becomes one of the difficult issues because it's also linked to not just the flag state's responsibilities under Article 94, but also the rights of the coastal state to protect its interests. It's going to have to be able to, or the enforcing state beyond the territorial sea limit, but especially the coastal state is going to have to communicate with that vessel. One quick issue: would you any of you have difficulty with a coastal state passing a law that requiring remote controlled vessels or mass vessels to navigate in sea lanes as they pass through territorial sea, so that at least the coastal state would have to be able to, they know where they are? The coastal state has the right to establish sea lanes in its territorial sea under UNCLOS. But what about not only sea lanes, but actually a mandatory ship reporting? That whoever is in charge of the ship would have to report to the coastal state to say, we are about to exercise passage through your territorial sea. Would that be imposed? The U.S. Navy might oppose that as required, as the equivalent of a notification requirement, but which is they would argue is violates innocent passage. But from the coastal state's point of view, they probably would want to have notice as to where the unmanned vessels are going to navigate, and therefore they could, you at least know where these people are and where these ships are and how you might communicate with them. Anybody have thoughts on that issue?
But in my view, again, once we're dealing with sort of larger size mass, the cargo type mass, again, and I think further to Anna's point that we would expect them to be following all the safety requirements, and that they should be using sea lanes, as you indicate, and any reporting requirements that are imposed on commercial vessels, including for the ISPS code, for example. We should still expect those regulations could be followed. Again, it comes back to your point about communication and how is that communication done. In the information that is needed is given, but what if there's follow-up questions of what happens if you're going a bit off script? But the question did also come to me in terms of if we start talking about prior notice for maritime autonomous vehicles, do we start getting into that realm of questions about prior notice for the exercise of NSRs, allow the coastal state to adopt laws and regulations for the safety of navigation? That is still subject to other rules of international law, and I think it would be argued that that would preclude the possibility of requesting prior notice, particularly for state-owned vessels. So I think you could anticipate some resistance if the advent of maritime autonomous vehicles was seen as a way of trying to bring that particular rule to the fore. Again, I think slightly different for your commercial vessels, though.
Okay, I think I got you. You faded a little bit. I think I understood you, but okay, Anna, you have another point.
Yeah, just for the ship reporting systems, if I take the SOLAS ship reporting system, SOLAS seem to apply to all ships, and at least chapter 5 on safety of navigation, and SOLAS doesn't define the notion of ship, but simply refers to domestic law. So if unmanned cargo vessels, for instance, are registered under domestic law, so they would be a ship under SOLAS, and also the ship reporting system rules. And where I see a problem, that you need a demonstrated need, that you need such ship reporting system to ensure safety at sea. And if you have such reporting system for all types of mass, it's maybe too sweeping, because some may be as safe as traditional ships. And there is also the rule, or in the SOLAS, it says that these reporting systems must comply with international rules, and notably UNCLOS. And there we have Article 24, which says that a coastal state shall not hamper innocent passage and not set up requirements which practically deny innocent passage. So if there is a ship reporting system under SOLAS for traditional ships, I guess you can well argue that this should extend to mass. That seems obvious to me, but to have one for all mass and solely mass could maybe be not fulfill the demonstrated need for such system. But of course, then it depends on the individual case. But I guess one needs to be careful in assessing whether the requirements are met. And then the SOLAS rules on these reporting systems, they are, as most of rules of SOLAS, very much geared to a master being on board, and it explicitly says that the master of a ship shall comply with the requirements, reporting requirements, and that it should report to the appropriate authorities. And who is the master? That's one of the common themes and gaps identified during that scoping exercise. And so if that mass scope would clarify who is the master for purposes of IMO rules, so we would then have, or the rule on ship reporting systems would be applicable to mass. And I guess when it comes to the interaction between the shore-based authority and the participating ship in such a system, we already now with traditional ships have this trend toward documentation requirements being satisfied electronically, and reporting to become increasingly passive. So that's a trend which we have with traditional ships as well, with automated identification systems and data exchange systems. So already there it's passive, and that technology could be equally used for mass.
Yeah, I would think that technology should be used for mass, especially when they're exercising innocent passage or transit passage in waters under sovereignty. So the coastal state knows which vessels are passing through its waters. Before we get to the questions, maybe we could move a little bit to the issue of naval vessels. And coming back to the point that there is no definition of ship in the Law of the Sea Convention, and there's various definitions in some of the IMO conventions. But the question, of course, would be to what extent should there be regulations, or should the coastal state be able to limit the passage of government vessels that are autonomous in one way or another? And that comes to the point of, for example, the right of innocent passage. Another undefined term is the Law of the Sea Convention, Article 20, says that all vessels have a right of innocent passage, but submarines and other underwater vehicles must navigate on the surface and fly their flag. Now, I'm not sure to the extent that some of the drones or other equipment being used by various navies would be classified as an underwater vehicle, but I doubt very much whether they would be able to surface and fly their flag. And therefore, a coastal state might argue that they don't have a right of innocent passage. I'm wondering whether people want to be. Pia, do you want to take off on that one? I think you've been doing some work on this.
Sure, Prof. So I think at the very basic level, the problem is really the terminology and the differing use of terms that of states, as you already said. So there's at the most fundamental level, the question of ships or vessels is always going to be there. And then UNCLOS further anchors the definition of warship to that ship status, ships belonging to the armed forces. So you have that dual two-level question of what rights will be accorded, and how coastal states that want to be cautious about the treatment of such kinds of vessels within their waters would think about it. The two leading perspectives on this one are as follows. One is reflected in the practice of the U.S. Navy, reflected in their Commander's Handbook, which is that there is independent status for such
Yeah, the U.S. Commander's Handbook seems to suggest that vessels have a right of passage, and they have unmanned systems have a right of passage through the territorial sea. But if that unmanned system is going underwater, I would challenge that, and I think a lot of coastal states would. Because it's quite clear on territorial sea that if an underwater vehicle must surface and fly their flag, well, if your drone or other unmanned equipment cannot surface and identify their flag, then they don't have a right of innocent passage through, in my view. I think this is we can look at this from the point of view of the naval power that wants to exercise their rights of so-called freedoms of navigation and naval operations in waters outside of sovereignty, and then the rights of passage, either transit or archipelagic sea lanes, or innocent passage through waters under sovereignty. And you balance that again against the historic position of the coastal states that it's concerned about maritime security from foreign vessels. And I think mass creates some new issues that are going to have to be more fully addressed in one way or another. Pia, are you with us on? Were you going to tell us what the German handbook says?
Yes, Prof. Sorry. Okay, not until that point. Okay.
Maybe you can turn off your video and just use your sound. You might have a better Claire.
Okay, yeah. So yeah, the approach to the German manual is a little bit more passive in that the UUVs could have warship status, but it's not as explicit as if it's a contrary perspective to the definition. There are other military manuals that could potentially accommodate UUVs under their characterization of auxiliary vessels, although some of them also have within the definitions auxiliary vessels that are manned. So So we have again a question of what are the, is there a possibility that there could be consistent terminology in this area, which is probably not, there's also some benefit to that ambiguity in terms of operational ease. And we did, you did mention some of the terms that appear in UNCLOS, like underwater vehicles. There's all sorts to device, and some of, I think, on this issue would take other characteristics indicative of do we give a kind of status to these UVs separate from either war or government vessels and non-commercial vessels. So those are some of the basic directions.
Okay, I didn't catch everything. You're very crackly, but Natalie, you want to try to come in on this, and I could interject again, or Anna can as well.
Sure. I mean, I think Pia was also mentioning the distinction that comes up with Naval Auxiliaries as well, where I think the definition is much broader than warships, and they could potentially fall under that, which is particularly relevant, of course, once we start talking about laws of naval warfare, but we're not going there really tonight. But I tend to agree with what you said, Bob, in any event, in terms of it's a vessel that has the right of innocent passage. So if you're going to claim the right of innocent passage, then the vehicle as such has to operate as a vessel as such. And I think we're right to expect that, you know, your other underwater vehicle, to have the right of innocent passage, has to be able to surface, and it needs to be clearly marked. You know, as we expect with the exercise of the right of visit and the right of hot pursuit, it's stated quite clearly in those provisions about how the relevant policing vessel needs to be clearly marked and identifiable. And I think we have that expectation, and there's flow-on effects then for immunity as well, particularly once you have China or Indonesia starting to seize these little, you know, torpedo-shaped vehicles that are being used for surveillance. If that is not a vessel, then a question arises as to whether they really have immunity, or what sort of immunity do they actually have. And there I think we start entering into more questions once again.
Yeah, because once they're collecting intelligence or information, whatever, it's no longer innocent passage.
Yeah.
So there would be, now the different rules may apply with respect to transit passage and archipelagic sea lanes passage. Because there they don't have to surface, they can transit in their normal mode. But when it comes to innocent passage,
and then it's a question of what's the normal mode for the relevant vehicle. So that kind of opens up.
So you're back to
issues.
But I think I know how the navies would argue the normal mode for an underwater vehicle is underwater.
Absolutely, and again, to operate all that equipment too. So
well, but it's
sorry, I think I jumped in.
Right, it's to transit. Their right is not to spy. The right is not to carry on any research or activity. So even in transit passage, there are limits on what the vessel can do. It can transit in its own mode, but it cannot engage, in my view, in intelligence collection and so on.
Well, so long, and if that intelligence gathering goes beyond what is incidental to.
Well, incidental to the passage. I think intelligence gathering would be incidental to the passage. So that's a debate I think some tribunal might have at some stage.
True enough.
Maybe we should.
Sorry, 30 minutes.
Go ahead. You were going to reply to that, Natalie?
No, I was thinking, I saw Anna and Pia also have their mics on, so I should let them come in on this.
Okay. Anna, do you have anything more to add on that particular issue? Otherwise, I think we would perhaps move to some of the questions, and then maybe we can ask all of you to reply. We have about at least 10 questions or so from the audience.
Yeah. No, I guess it's fine. I agree with what has been said. If it's innocent passage, then you have also to comply with the rules. And I guess Article 20 is quite clear that you have to submerged passage, it's non-innocent. But there will also be many devices which may not qualify as ships, which is the precondition for innocent passage to apply. And there is a concept which is called ocean of things, the kind of maritime analog to the Internet of Things. And the idea, that's a concept which the US Navy has put forward. And under this concept, you would have many low-cost drifting floats, small devices in the water to enhance situational awareness. And these are maybe rather devices or equipment. So where can you use them, etc. So these are interesting questions coming up. And we have a lot of crafts which do not really look like a ship, but are still registered as ships. For instance, the UK Navy, they have registered, I guess, more than 20 different types of vessels with some form of autonomous capability. And some really do not look like a vessel or a ship, but this is important for like immunity, but also for passage rights, and but also for accountability, and that you know that these are UK assets. But where do we draw the line between a ship and then devices or equipment? So that line to me is not utterly clear.
Okay, spot on. I completely agree with you. I think the UK position also is whatever they define as a ship, the rest of the world must accept. But my guess is there are many countries in the world or states that would say, no, we don't have to accept your definition. And if you start there is no definition of ship or vessel in Law of the Sea Convention. They're used interchangeably depending on which committee drafted the provisions. Various IMO conventions have definitions of ships, but when we come back to Article 94 and whatever, it's quite subjective what a ship is. And I don't think the answer, looking at the law of the sea, is every state has a, you can, if you call something that flies a ship, then it's still a ship and everybody must recognize that. I don't think that's the case. But how we resolve this issue is going to be exceedingly complicated. But it's the unresolved issue, I think, because nobody gave a definition in the Law of the Sea Convention.
Prof, if I may just add, the technology is also evolving towards, you know, this very small craft that they go on their mission for months and then they return to base, and then within 20 minutes you replace the battery and they're sent back again. So the body of the ship is, you know, it calls to mind some of those questions again. When your ship is changing that quickly in terms of its components, could that affect your understanding of what the vessel is?
Yeah, well, just go to a dictionary and you'll find that the definitions for vessel, boat, craft, and ship are interchangeably used, and there's clearly no definition. Even if you go to any of the English or American dictionaries, and they define one by using the other. A vessel is a large boat, or a vessel is a large craft, or a craft is a small boat, or whatever. But the problem is which are ships that have the rights and which can states prohibit. And you can clearly prohibit spying equipment from entering your territory. And then the question is, how do you distinguish between equipment and ships or vessels? And we can't answer that one today. We can't resolve it. We'll wait for Natalie's report on that one. Okay, we have some questions from the floor. Open to the panel. Under current UNCLOS can law enforcement jam signals to disorient or change course an autonomous maritime vehicle that's suspected of having a malicious intent? Anybody want to take a stab at that one? You defend yourself as a coastal state by jamming the electronics on your autonomous vessel.
I would think, yes, it would be part of your scale of responses. It would not necessarily be the first thing that you would do to a ship, but to the extent we talk about fouling propellers or otherwise trying to disable a ship from operating, it would start falling within that zone of response under, I think, your rules of engagement in law enforcement efforts.
Okay, good. Anybody want to add anything? Sounds reasonable to me. Second question, I was wondering what would be the implications of remotely controlled autonomous fishing vessels on maritime security and conservation of marine living resources, and how do you address the issues? That's one we haven't thought about here. Remotely controlled fishing vessels. Any thoughts quickly?
At least in what is discussed is rather the other way around, that you would use autonomous enforcer vessels to contribute to the prevention or also disruption of illegal fishing activities. And there you have different smaller systems which are used to monitor borders, to detect other vessels engaged in illegal fishing. And that's just one of the examples which testify to the fact that the enforcement capacities or the reach could be extended by using these types of enforcer vessels, because they're much less costly, you can have more of them, so you can monitor greater areas as compared to a fully fledged patrol boat or even a warship. The same for counter-drug operations. I read the impressive figures of the cost of a US destroyer used for patrolling the seas, and it's $700,000 per day. So if you compare that to a smaller device which can do some of the tasks, then there are good reasons to invest in this technology. But as regards like autonomous fishing vessels, I don't know. At the moment, this is still a very cost-intensive technology. So I don't know. This industry is already under very much cost pressure, and I don't know whether companies would invest in autonomous technology to do fishing. But I don't know. Maybe others have more concrete ideas.
Yeah, you flipped it in a way that it's very useful, I think. We were thinking of coastal states trying to protect their interests of autonomous vessels entering their waters, but you raise a very legitimate point that coastal states can use autonomous vessels to patrol their waters from illegal activity, including their economic zone from illegal fishing or surveys, etc. So that is another interesting element, is that they can become a tool for the coastal states to enforce their rights over natural resources, as well as protect their security interests in their waters. To what extent could the coastal state rely on the fact that the mass is unregistered to exercise jurisdiction? We've covered that a little bit. Somebody want to summarize? If you find out the mass is not registered, can you then exercise jurisdiction?
Yes, I'd expect it to be treated as a stateless vessel.
Stateless vessel, anyone has jurisdiction on the high seas. If it's in your territorial waters or archipelagic waters, it's your jurisdiction anyway. So yes. The address, the port authority and destination could be replaced by the coastal authority. Coastal state authority versus port authority. Not sure what's intended by that other than the coastal state or port state enforcing their rights. So it's a question of whether that vessel would have to report into, rather than to the port, to the coastal state authorities, but that could be done through the port. I'll just leave it at that, I think. Can a coastal state restrict the right of navigation for autonomous vessels beyond national jurisdiction, meaning outside territorial sea? Answer clearly no, they probably can't restrict navigation. The question whether they can restrict it to what extent within their territorial waters or archipelagic waters. What is the legal responsibility of the mast officially registered owner if the mass's control was taken over by malicious cyber attacker and then caused an accident or created a fatal disaster. That's getting into private international law. Here you have a registered mast, but somebody uses a cyber attack and takes it over, and then it is an accident. To what extent is the original owner? That's this is a private international maritime law issue more than public. We're a bunch of law of the sea experts. Natalie, if you can take a stab at this one.
Yeah, no, I really don't want to. I think it is a maritime law question in terms of the liability of the owner. I think otherwise, going back to my safe zone of law of the sea, that it still would fall to a flag stage for an incident of navigation to undertake its to do the inquiry as would be expected under UNCLOS.
I guess what are the obligations on the flag state if it finds out that a vessel under its flag has been taken over by a third operator of some kind? Probably would send out a signal to anybody in the area to intercept that vessel or whatever. That's what I would think. But private law, it's the private maritime lawyers, the guys that make all the money. They're the ones that can answer this, not we academics. Safety and security of the vessel is the responsibility of the owner, operator, and the flag state where the ship is registered. Coastal states should be able to communicate with either one for whatever information they require. It's more of a statement than a comment. It's probably correct. Question again is, are the mast vessels through the IMO rules going to be equipped to be able to communicate to the coastal state, or the coastal state be able to communicate with them?
I mean, you would expect, again, if the mass is of a certain size, that it's going to have AIS and be subject to the long-range identification and tracking regulations in any event. So there would still be some information. Again, it's just the smaller craft that would not necessarily.
And we should recall that there's a large number of vessels that don't fall under a lot of the IMO conventions. Each IMO convention has their own definition, and the so-called non-convention vessels are a continued headache in terms of their safety, but also the sometimes pollution.
To follow up on the different types of ships to engage in crime, I also expect to be a shift there. Why would you smuggle drugs in a cargo ship when you can use an underwater autonomous or remote controlled vehicles? I guess there could also be shifts to not using traditional ships where it's more likely maybe to be detected and where you have port security, etc. So I guess as already today, usually smaller crafts are used, non-registered crafts to engage in crime. And I would expect that to become even more likely because, there are lots of advantages using smaller autonomous or remote controlled crafts for offenders.
Okay, I got one that might be, again, Anna's cup of tea here. What kind of arguments or defense would you say could the captain of a vessel make if the coastal state claims non-innocent passage to repress against NGOs that conduct, for example, human rights monitoring, as is happening on European external borders in light of grave human rights violations against people on the move? I think we're talking here about, I don't know if it's the English Channel or across the Mediterranean, but again, smuggling of people or transport of people into territorial sea it's not innocent passage. It's the right of the coastal state to try to prevent it. But then it gets into the human rights elements. Anna, you've written on that, I think. Do you have any issues, any comments on this one?
As regards like protesters at sea, for instance, there could be the danger of states not seeing that as a legitimate activity, which is also allowed under human rights law, like the right to communicate or right to assembly, etc. Because in the list of non-innocent activities, you have this any act of propaganda aimed at affecting the defense or security of the coastal state. So that's kind of a dangerous clause which could be used to prevent legitimate NGO protests at sea. And there has been some cases before the European Court of Human Rights where ships were used for different human rights purposes, or to raise awareness about human rights abuses or violations, and these ships have been expelled from the territorial sea, arguing that this was not non-innocent passage. So I guess much depends on the concrete activities of NGOs in the territorial sea and whether it falls under that clause of act of propaganda. If I have understood the question correctly, my connection was not very good at the moment.
Okay. Could
I just add to that, Bob, just
Sure.
before we move on, because I think the question also goes to the fact that there have been some NGOs that have been using aerial drones. Let's turn my video off. Just turning my video off in an abundance of caution. That have been using drones to detect vessels that are in distress and then to send NGO vessels out for rescue. And I think the question also goes partly to this idea of ships in distress being able to enter into port. So when the vessel is in distress, then it's not really a question of innocent passage as such. And I think it's also important to bear in mind that when we start talking about policing obligations around migrant smuggling, that the rights of the coastal state are still subject to human rights obligations, which would include the obligation of non-refoulement as well. So I think those facets might also be relevant here.
Okay, very good. Those are issues that sort of go beyond the autonomous vessel issue. These are basically the issue, interplay between international human rights law and law of the sea and so on, which is a little bit beyond the scope of this workshop. Next question, what is the effect of AIS spoofing on the safety of navigation, navigating in proximity of masts? Anybody up into the technology of AIS spoofing and other people either turning their AIS off or somehow trying to send a false signal up as to their identity? How would that link to in the proximity of mass? I guess it's my quick comment would be, without thinking it through that much, is that the masts, in order to be safe, are going to have to be able to communicate with the surrounding vessels, whether they're going through, especially if they're in choke points or sea lanes in which there's heavy traffic. If you're talking about something like Straits of Malacca and Singapore, then you don't want AIS spoofing. You want to be able to see what is around you. And I guess the question is, if false signals are coming out and therefore the mast is misreading where the vessels are, might there again are coming back into private liability issues again, I think, or international maritime law. That's unless somebody else, that's just something there that I don't see. Does anybody have a comment on that?
Well, I think, Prof, the direction towards which the technology is being developed right now is to increase all of the other types of sensors that are on board these unmanned vessels. So it could be not just AIS, but other sensory equipment that could be on board these vessels that could help. And that's a design matter that might be discussed again at the IMO level, and will bleed into the discussion on what are your gyres in terms of construction and equipment.
Yeah, this is one that I think would be under the ambit of the IMO, not the law of the sea. They're the ones that are going to have to deal with the technical specifications.
And I guess
this one is way outside the ambit. Sorry, do you have Anna? Do you want to say this?
just to follow up, I guess it's not a problem only relevant for mass, but also in terms of traditional shipping. And I guess there's quite a development now as regards like communication, monitoring, reporting. The IMO has also a work stream called e-navigation, and that's for traditional ships. So also in the traditional shipping domain, we have developments. And as regards the IMO, one of the topics identified for discussion, which cuts across all conventions, is cybersecurity and connectivity. And so that's certainly on the radar of the organization.
Okay, good. I have a question just to get your comments outside the ambit of this workshop, but should there be a cap on the deployment of nuclear vessels by states and their navies? The number seems to be only increasing. I'm not sure whether a study's been done on this yet. I think they just want to comment on should there be a limit on nuclear vessels, or how does the whole issue of autonomy, I think it's outside the ambit, but anybody have any ideas on this? I think the general, what we're seeing now is states saying nuclear powered or vessels carrying radioactive substances. Some states are saying they must give notice before exercising innocent passage, and your traditional naval powers will say there's no such obligation. Only obligations are those that carry the documents required by IMO and IAEA. But I don't think there's any discussion about limiting the nuclear vessels.
My only thought would be at what point do you start saying it's so prejudicial to the marine environment, or such great risk to the marine environment, that you could start bringing, those kind of precautionary type principles in, that connection is not typically made. But once you start talking about sheer quantity of them, perhaps there is scope for it.
Okay, good. Okay, I think we're almost taking care of the questions. Unless, Dawoon, if I missed one, let me know. Otherwise, perhaps we're about 10 minutes, 9 minutes left, I guess, to the scheduled time. I'd like to give everybody the opportunity to make some closing comments or thoughts on how the workshop has gone and what issues are left to be resolved, particularly on the law of the sea issues that are not being dealt with by the IMO. Anybody want to give this first crack?
Well, I was going to give it my first crack until you said it relating specifically to law of the sea, because where I actually think there needs to be also much more work is around domestic laws. Once we start talking about enforcement of coastal state laws and making sure that in the coastal state regulations and also criminal legislation that they're taking account of sort of participation or aiding and abetting type offences, that they're not going to be scooping in the people who design these vessels that are not supposed to be used for criminal purposes but end up being used for criminal purposes. Is the designer or the maker of the vessel going to get some responsibility? So I think there's also a lot of work to be done domestically around that as well, just to make sure that that kind of regulatory regime is also consistent with whatever we're doing in the international law space. But I think in the international law space, a lot of the work is around, first of all, our definitional issues, as you say, in terms of the vessel and vehicle interface, and also thinking very carefully about what kind of rules we need that can allow for emerging technology. So, Anna's point about the evolutive types of interpretation and how appropriate that is, I think is a point well made. I probably am a bit more progressive in the way that I like to think about it, to try and extrapolate from existing principles, but that can only go so far in the end. So I think we do need to try and get some more certainty around the existing rules and what's allowed for these sorts of vessels to ensure that whatever the size and functionality, that we can understand what the rights and duties are of all the different stakeholders.
Okay, very good. Anna.
Yeah, I guess there are indeed many issues, and the IMO has done this scoping exercise, and it also covered the 4 SUA conventions, but it's still a very superficial review of these conventions because it was a provision by provision review. For instance, you would then cover all the crimes or the entire safeguards provisions, and there's so many aspects in each of these provisions, so it's still kind of a broad brush review. So I guess as regards maritime security, we are not yet at the level as we are for other conventions. There's still a lot of issues which have not been detected or discussed. And for the SUA convention, we have this IMO venue where you can have the discussion. But when it comes to maritime security, we have a lot of other conventions, namely those which were adopted under the auspices of the UNODC, and I don't see any concrete law reform steps. Of course, there are reports on artificial intelligence, autonomy by UNODC, but how do we go about for this convention? And it's true, many things can be revised under domestic law, but still the entire transnational criminal law is predicated on the idea of harmonizing substantive law in order then to facilitate the international cooperation in criminal matters. So I guess there needs maybe not amendments to the convention, but at least a common understanding what the offenses mean, and including the safeguards for enforcement measures, etc. So I guess it needs both domestic activity, but also an international framework which sets out the parameters for this new technology. And I doubt whether we will open many of these treaties. I can very well understand the reasons for not opening, for instance, a SUA convention or a SUA protocol. Maybe informal law could be an avenue to pursue. Natalie worked on this a lot. And yeah, so there is certainly enough work for all academics involved in the question of autonomous ships.
Okay, Pia.
Yes, Prof. I wasn't sure. I'm not sure if this was discussed while I was out earlier, but maybe some points in the convention that might be impacted by the confusing terminology, aside from what we've discussed, would be the exercise of rights to marine scientific research, and of course the ever contentious notion of military activities, and what are the implications again on the use of force and dispute settlement in relation to that discussion. The technology is also bound to move probably towards weaponization of these UUVs, and while the law of naval warfare is outside our scope today, that is another area that is of concern to the states that develop this, of course, and the matter of how they safeguard these devices or these vessels from the possibility of hostile takeovers, and how do they ensure that even after the recovery of these vessels, when they come to home base, they have not been tampered with, and so that might be an issue of concern. So I guess in the area of military vessels, there's an interest on one hand to harmonize our understanding for better for operational ease, but at the same time there is some comfort in the ambiguity, I think, as these technologies are still developing. What would be important would be when the definitions come out from state practice, that these very states that are heavily involved in the development of these UUVs, USVs, would be ready to accord the same status to UUVs and USVs of other nations that may be operating within waters under their jurisdiction. So how ready are they to honor or to accept that kind of exercise of navigational right or other privileges under the convention?
Okay, thank you all very much. I think what our audience can see is that particularly with the Law of the Sea Convention, which is extremely difficult to almost impossible to amend. We've got a convention drafted in 1982 or adopted in 82, reflecting the values of the 70s and the science and technology of the 70s. And now technology, as usual, is way ahead of the law. And the lawyers are struggling as to how we attempt to bring the law up to date to keep pace with technology. And in some issues, particularly with the law of the sea, it's more challenging than others because we can't simply amend the conventions. The IMO can amend their main conventions quite easily, but the law of the sea convention, it's much more of a challenge. So hopefully we've shed some light on some of the issues relating to the issue of mass and maritime law enforcement and maritime security. I'd like to thank our panelists very much for their time and coping a little bit with the technological issues. I thank our audience for their patience in staying with us, and we hope that everybody's benefited by this, and we hope to be working with Natalie and Anna again. We thank you again for joining us, and Pia, of course. So we welcome you back from France soon. So thank you all very much. I'd like to call it to a close.
Thanks very much.